Hello, and thank you for joining us. My name is Julie Rose, and I would like to welcome you to today's webinar, Preventing Harassment and Creating a Respectful Workplace. Our presenter today is Alice Baker, an attorney who specializes in labor and employment law. Before we begin, I would like to go over a few pieces of information about the webinar. To avoid interruptions to the presentation, all attendees are in listen-only mode. You can still ask questions using the Q&A box in the lower portion of the webinar dashboard. We do have a full agenda for today's presentation. If you submit a question and there is not time at the end to address it, we will have someone contact you. Today's presentation is available on the CPS HR Consulting website. We'll also forward a link to all of today's attendees once the recording is available for viewing. And now I'll turn the presentation over to Alice.
Thank you, Julie, and welcome to everyone who is participating in today's webinar. We have a very, very busy schedule, so we're going to move forward and we will plow through moving very quickly. Let me give you a quick idea of some of the things that we're going to be doing today. What we have on tap is we're going to start out by talking about various and sundry classes of people who are protected by state and federal law against discrimination in the workplace. We will talk a little bit about the evolving legal landscape, that is, the way that the laws have changed over the last 20 or 30 years and some of the directions in which trends are moving. We will then move forward and talk about some legal definitions. The legal definition of harassment, what is it? What kind of conduct can get you in trouble, can get you a lawsuit? What kinds of trouble can you get into? We will then go back and to some legally protected classes and focus on a few specific legally protected classes in more detail, a few issues, things that make them a little bit more different or unique or more worthy of specific mention. As a subset of that, we will be talking about some issues that are unique to sexual harassment. We will do that in some detail. We will then move forward and talk about prevention, some strategies for creating a respectful workplace. And then I've got a section here that says questions and answers if time permits. As Julie indicated, we have a very full schedule today. We have already received a number of questions in writing from people who are registered for the workshop. I've created a few slides with those. I will cover them as time permits. It is unlikely that we will be able to get even to all of those. But we will do as much as we possibly can. And then if you have other questions, we encourage you to ask them and we will get back to you. There is one thing you may notice is missing from this slide, and that is the procedures for reporting and responding to complaints of unlawful harassment. Because of the time constraints that we have, there's only 1 hour for this webinar. We just didn't have time to cover everything. Something had to give, and that's the thing that we made a decision we didn't have enough time to cover. Let's get right into things. Current protected classes. Federal law covers and protects a variety of people against being discriminated against in the workplace on the basis of their membership in any of these protected classes. Title VII of the Civil Rights Act of 1964 makes it unlawful to discriminate against any employee with respect to their race, color, religion, sex, or national origin. The Age Discrimination in Employment Act prohibits employer discrimination against employees who are age 40 and older. The Americans with Disabilities Act prohibits discrimination on the basis of disability. The Genetic Information Non-Discrimination Act, GINA, prohibits discrimination on the basis of a person's genetic information, and USERRA, which I can never remember what it stands for, Uniform Services Employee something Act, prohibits unlawful discrimination against people on the basis of their military and veteran status or current military obligations. These are the federal statuses. Most state law offers additional protections above and beyond what federal law provides for. So we have the federal categories, and then as an example, I've given you some additional protections under California state law. A side note on this, for those of you who are not from California, I will be referring to California law a lot today. Our pre-registration numbers indicated that about 2/3 of the people who are participating in the webinar are from California. So they're going to get a little bit more than their fair share of discussion. That doesn't mean that we want to ignore the rest of you, but this is an example of the kinds of things that a state statute could protect. Under California law, it is illegal to discriminate against somebody because of their ancestry, their sexual orientation, gender identity, and gender expression, medical conditions, marital status. So there are all sorts of additional categories that can be protected. More on that in a couple of minutes. What kind of trouble can you get into if you discriminate? Well, under federal law, the employer is the one who is liable when discrimination happens. The employer is not usually going to be the actor when you're talking about hostile environment discrimination or harassment. Usually, what you've got is an employee who is engaging in misconduct. Nevertheless, the employer has an affirmative legal obligation to take reasonable steps to deter this particular brand of misconduct. The employer can be sued by the employee and is liable for failure to take reasonable steps to prevent and deter harassment, to stop harassment if it occurs, to investigate claims of harassment, and finally, to protect employees who complain about harassment or oppose harassment against acts of retaliation by the employer or by their co-workers. That's the federal rule. There are some additional bases of liability under the laws of some states. California is one of them. It's not the only one. There are several states that also make supervisors and employees who harass individually liable, and they can be sued in court personally. So if you're from California, the District of Columbia, New York, Ohio, Oregon, Washington State, a few other jurisdictions, the supervisor can be liable in addition to the employer for acts of harassment that they personally engage in, or for harassment that happens on their watch if they actively or tacitly encouraged it. And then the employee who is a wrongdoer can also be liable for the harassment that they have personally committed. This is a minority rule, California and a few other jurisdictions, but regardless of what state you live in, there is an increasing trend towards liability for individual harassers. If the state does not have a statute like California's that allows for individual liability, plaintiff employees are increasingly bringing lawsuits against their co-workers and supervisors, raising claims like assault, battery, defamation, invasion of privacy, intentional infliction of emotional distress, negligent infliction of emotional distress, intentional interference with employment relations. There are a whole lot of claims that people are starting to bring against individual harassers when the harassing conduct is serious enough that it itself can be a separate tort, a separate legal wrong, such as assault or battery. And then finally, of course, the individual harasser, because they are certainly violating an employer's zero tolerance policy, can be subjected to the employer's progressive discipline system and up to and including termination from employment. So what are some of these protected classes? There has been a trend over the last several years of increasing the number of people who are protected and the types of legal claims that are available to people. This business of plaintiffs bringing lawsuits for things like assault and battery or intentional infliction of emotional distress against individual harassers is actually a fairly new phenomenon. And the number of categories of people who are protected is also increasing at a rapid rate. In the early 1960s, we start including things like race, color, religion. Moving forward, we get age. In the 1990s, we've got this development in the area of disability law. Also in the 1990s and going into the 2000s, sexual orientation and increasingly gender identity is protected. Coming up for the future, lawful products, laws that protect people from being discriminated against because they smoke. Laws that protect people from being discriminated against on the basis of prior criminal records that have nothing to do with the job that they're applying for. And we find that these new protected classes are cropping up all over the place. Let me give you just a few quick examples of the kinds of things that are coming on the horizon. I've identified a few regional hotspots on this map. If you live in any of these jurisdictions, these are the areas of the country where you need to be extra careful, extra aware. You see a lot of additional protections. The United States in the West, pretty much anything that touches the Pacific Ocean, you got to watch out. Colorado, New Mexico are off kind of in that area. There's an area sort of in the Great Lakes region. Illinois and Minnesota are the big ones, but also Wisconsin, Iowa, Indiana, Michigan, Ohio. We see a lot of activity happening in that area. And then finally in the Northeast, sort of centered in New York State, but also several jurisdictions that abut New York State. That's where we tend to see the most action. Let me give you an example of how some of this works. I'm going to use sexual orientation and gender identity as my example. It's the biggest one. It's the current one. It's the one that we see all over the news. The map that I've given you here shows the states that prohibit sexual orientation discrimination in public sector employment. Almost all of these states today also do prohibit gender identity discrimination in public sector employment as well. I realize that the numbers are a little bit small on this, but I want you to look at the line here. This is a time graph showing the number of states with laws that prohibit sexual orientation and or gender identity discrimination in public sector employment. The numbers are not as important as the direction that you see the numbers going. 25 years ago when I was in law school, sexual orientation was just barely beginning to come into its own as being protected. And then we've got this 20-year period where it takes off. There's a steady increase in the number of jurisdictions that were provided with this protection, and then today, about 2/3 of the United States population is protected by a statute that prohibits sexual orientation discrimination in public sector employment. The next wave that we see happening here is exactly 10 years later, and it's gender identity discrimination. If you look at the slope of these two lines, the is exactly the same. 20 years ago, these statutes were virtually unknown. Today, over half of all states prohibit public sector employers from discriminating against their employees on the basis of gender identity. There's somewhat less protection in the private sector, but this is a public sector. You see that it's happening. It's very, very common. So the fact that 2/3 of the states currently protect employees from being discriminated against on the basis of sexual orientation and or gender identity is not as important as this overall trend. If you live in any of these states that I've got covered in green, you got to obey existing law. If you live in one that's not covered yet, consider the trend lines that I showed you a moment ago. We find the same thing happening in a whole lot of other areas of law. Criminal history is another very, very recent trend. These were virtually unknown 20 years ago, and then now we look and we see that most of the country is covered by some sort of statute that places restrictions on whether and the extent to which an employer can consider an applicant's criminal history. Lifestyle discrimination, discriminating against an employee because they smoke tobacco. 20 years ago, virtually unknown. Today they exist in 30 states. Side note on lifestyle discrimination statutes and smoking, tobacco smoking, not marijuana smoking. It remains legal in every state to terminate an employee for marijuana use. Even in some of the states like, and I'm going to jump back here, you'll notice that Colorado and California both have lifestyle discrimination statutes. Both Colorado and California have decriminalized recreational marijuana use. Both states expressly provide by law that marijuana use, possession, smoking, having THC, and other marijuana metabolites in your system is not protected. The employer can fire you for that. This is an issue that comes up fairly often. I encounter it pretty regularly, so I'm just going to make a side note on that one. Another area, domestic violence, sexual violence, being stalking. This is another area where there was virtually no protection. But these are starting to come up. A lot of states, there used to be a problem with that victims of sexual violence or stalking would have if they tried to go to court to get a restraining order against the stalker or the abuser. They were at risk of losing their job for absenteeism. These days, an increasing number of states provide protection to victims of sexual violence, domestic violence, stalking, so that they can take care of what they need to take care of to protect themselves and not be at risk of losing their jobs for that. So we find all of these new protections on the horizon. Bottom line, it is best and nicest and wisest to treat everyone as though they belong to a protected class. There's a large number of protected classes. They are on the rise constantly. The fundamental idea of anti-discrimination law is that employees should be treated as individuals and not on the basis of stereotypes. This policy holds that an employer's decisions about hiring, pay, working conditions, terms of employment, employee discipline should be made on the basis of factors that are relevant to the work environment, such as education, training, and on-the-job performance. Characteristics like the ones that I've just gone over, race, sex, sexual orientation, all of the other laundry list, are very rarely relevant to the work environment. So even if you've got an employee who lives in a state where, for instance, sexual orientation is not a protected status, fair employers will make their decisions on the basis of factors that are relevant to the job and treat their employees on the basis of factors that are relevant to the job and not on factors that are not relevant to the job. Moving forward, let's look at the legal definition of harassment. Regardless of whether we are talking about harassment on the basis of race, color, sex, religion, national origin, sexual orientation, or anything else. The Supreme Court has given us some guidance under federal law. A hostile work environment is created, they tell us, when the workplace is filled with discriminatory intimidation, ridicule, and insult that is sufficiently severe or pervasive to alter the conditions of the victim's employment and create an abusive working environment. The conduct must be both objectively offensive, that is, something that a reasonable person in the victim's shoes could find offensive, and something that is subjectively something that the victim objects to. If they don't object, then they don't have an abusive work environment. How does this severe or pervasive test work? Well, I think that it's the best way to understand it is if you consider it as being two dimensions on a two-dimensional chart. With one of the lines I've got here, my horizontal axis, severe, and then my vertical axis I've got is pervasive. Severe or pervasive, it's an either or test. Anything that I've got here up in the red zone is a lawsuit. Note that this conduct can be severe without being pervasive, and you still got a lawsuit. One single serious act of discrimination. You slash somebody's tires. You punch somebody in the face. That's severe, even if it only happens once, you have a lawsuit. It is also possible to have conduct that is pervasive without being severe. The death of 1,000 paper cuts. Little tiny stuff that adds up over time and turns into a miserable experience for the employee. It's also possible to have conduct that is both severe and pervasive. That's where you get the 7-figure verdicts. Conduct that is neither severe nor pervasive does not give the victim a lawsuit, but again, that doesn't mean that it's okay. It can still be conduct that contributes to a lawsuit and can also be something that violates an employer's zero tolerance policy. Let's look quickly at the severe test. What is something that's severe enough that it could make a lawsuit even if it's the only thing that happens? Well, the Supreme Court says we're going to look at factors like how severe was the conduct? It's a little bit of a circular test. How bad was it? Was it something that was physically threatening or humiliating or a mere offensive utterance? Is this really bad, or is this something that just sort of makes you roll your eyes? Is this something that unreasonably interferes with work performance? Is this something that affects the employee's psychological well-being? Was the harasser a coworker or a supervisor? The severity is always upped when the harasser is a supervisor, because anytime a supervisor does something, it carries the weight of the employer's authority behind it in a way that may not be the case if the harasser is a peer. Well, what about pervasive? Conduct that is pervasive enough can give rise to a lawsuit even if it's relatively minor. Consider, for instance, my hypothetical and fictional character, Maria Rodriguez. Maria is fictional in the sense that she doesn't actually exist. She is non-fictional in the sense that the things that I'm about to tell you are a composite of 3 separate lawsuits that I put together into a single bad day. I don't deal in fiction. Fictional Maria Rodriguez was born in Fresno, California. She is of Mexican heritage and works for an unnamed state agency. At 8 o'clock in the morning, Maria walked into the office. A coworker said to her, "Hey, chica, looking sexy today." At 8:30, a coworker tried to engage Maria in a conversation about the World Cup finals. When Maria told the coworker that she didn't know very much about soccer, the coworker said, "No way, you Brazilians are all crazy for soccer." Really? It's the wrong continent. At 9 o'clock, Maria's computer started acting up. She stormed into the IT department and demanded that someone come to fix her computer. The IT tech said, "There goes the Mexican in you." At 10 o'clock, a member of the public, an immigrant who was not fluent in English, came to the window next to Maria's window. After helping the member of the public, Maria's coworker muttered several unflattering things under her breath about wetbacks who come to this country and don't bother to learn English. At 11 o'clock, somebody walked through the area around Maria's desk and said, "Smells like tacos in here." That's funny. Maria was under the impression that it was Chanel No. 5. At 11:30, A uniformed police officer walked through the lobby of the building. A coworker hissed at Maria. Migra alert! Better hide behind the counter. What's the bottom line for Maria's bad day? By the end of the morning, Maria has been subjected to 6 separate acts of discrimination committed by 6 separate people, none of whom is aware of the others. No single incident here is severe, but even though no single incident is severe, the 6 separate incidents add up to a ruined morning and do create a hostile workplace environment. This is why the rule for any individual employee has to be, don't do it even once, don't make even that single offhand comment, because they add up. Conduct that is severe enough can give rise to a lawsuit even if it only happens once. Conduct that is pervasive enough can give rise to a lawsuit even if it wasn't severe. The more severe the conduct, the less often it has to happen. The more pervasive the conduct, the less severe it has to be. The Supreme Court speaks of this as being a sliding scale. The minimum that you need in order to have a lawsuit is somewhere on that sliding scale, that line. Conduct that is neither severe nor pervasive, again, just because you don't have a lawsuit doesn't mean that it's okay. Let's move on and talk about some of the forms that harassment can take. These 4 forms that I've given you are for convenience only. They have no legal significance. Physical harassment, verbal harassment, nonverbal harassment, and inappropriate visual displays. Before I move on to those specific forms, I'm going to give you a bonus botany lesson. You didn't know you were going to get a bonus botany lesson today. This is a lesson about poisonous mushrooms. There is a mushroom that is fairly common in the United States called the jack-o'-lantern mushroom. The jack-o'-lantern is easy to find. It is easy to mistake for a delicious edible mushroom. It looks very much like a chanterelle. It smells good. It tastes good. The only problem is it's also highly toxic. If you were to consume a jack-o'-lantern mushroom, within 15 to 30 minutes, your body would recognize it as being poisonous, go into overdrive, and do everything in its power to get the toxin out of your system. You would be vomiting, you would have severe diarrhea, your eyes would water, you would be sweating, your heart would go into palpitations, your whole system would go into overdrive trying to get rid of this mushroom. For that reason, and because our body is very successful in getting rid of jack-o'-lantern mushrooms, the jack-o'-lantern mushroom doesn't kill people much. It is sometimes called the mushroom that won't kill you, it'll only make you wish you were dead. Compare and contrast a very different kind of mushroom, Amanita Phalloides. Amanita Phalloides is also toxic, and it contains a very different form of toxin. Amanita Phalloides toxin is more of a sneaky stealth toxin. Your body does not recognize it as being poisonous. You don't throw up. You don't get diarrhea. It sneaks around your system for somewhere between 6 and 24 hours, chewing up your liver, and then it goes on and it chews up your kidneys, and after it's done a lot of damage, you get very, very sick. You go to the hospital. At the emergency room, you enter stage 3 of Amanita Phalloides poisoning, which is a honeymoon phase. The victim appears to get better. You get released from the hospital, you go home, and you go into end-stage liver and kidney failure. If you don't get a transplant, you spend the rest of your life on dialysis or you die. The common name of Amanita Phalloides is the death cap. Death caps and their close cousins, the destroying angels, are estimated to be responsible for over 90% of mushroom poisoning deaths worldwide. What's the difference between a jack-o'-lantern and a death cap? The difference is your body immediately recognizes the poison in the jack-o'-lantern as being poisonous and gets rid of it. But your body does not recognize the poison in the death cap. In both cases, if you get to a doctor within 6 hours, you're going to be just fine. In both cases, if the poison stays in your system for 24 hours, you're going to be in very serious trouble. The difference is the one is obviously poisonous to your body and the other is not. Why do I give you the bonus botany lesson? The reason I give it to you is because in the world of discrimination and harassment, there are also death caps and there are jack-o'-lanterns. There's a lot of conduct that is obviously bad. Very few people need to be told that it is not okay to punch a coworker in the face because of their race, sex, or national origin. But a lot of people forget about those death caps. The danger spots are the ones that you're likely to engage in because they're not quite so obviously poisonous, but they can, in fact, get you in every bit as much trouble. For physical harassment, inappropriate touching, it is, of course, not okay to punch somebody in the face. But the danger spots are the things that are closer to the line, conduct that goes under the name of horseplay, kidding around, joking, hazing. Watch out for that kind of conduct. Hugging people can be a real issue in the workplace. If it's huggers versus non-huggers, the non-huggers win. Bear hugs do not belong in the workplace at all. Supervisors should never hug subordinate workers. Now, if you are with a peer, and if you are 100% confident that that person doesn't mind being hugged, a side hug is okay. But you have to be 100% certain. And this is why I say supervisors should never hug subordinates. Because when you are the supervisor, you can never be 100% certain. Your subordinate employee whom you supervise might feel uncomfortable saying, "Get your scummy hands off of me." So don't hug them. Don't invade their personal space. Don't get too close to people. If you have a coworker who is looking at a computer screen and you need to look on with them, don't hang over their shoulder. Pull up your own chair. One real dangerous spot is off-duty conduct, especially now that we're in January. Every year in January, we see a spike in the number of sexual harassment claims that are filed nationwide. These happen because of holiday parties at which people get plastered and start groping each other, and then a few weeks later, people file complaints. Be aware that off-duty conduct at any work-related event, an office party, while you're on break, in the employer's parking lot, does count as workplace-related conduct and can give rise to a sexual harassment claim. Watch conduct that you're engaged in even when you're off-duty. Verbal harassments, few danger spots. Racial or ethnic or sexual slurs of any kind do not belong in the workplace. Insults. Insults of any form do not belong in the workplace, but especially if they are based on somebody's membership in a protected class, they are absolutely not appropriate. Jokes, if a joke is not safe for work, take that seriously. Not safe for work means it's not safe for work. Leave it at home. Teasing, something that we hear a lot, and we get a lot of complaints about this in the workplace, is people being addressed by inappropriate forms of address like honey, sweetie, baby, darling. Your coworker is not named honey, sweetie, baby, or darling. Not unless their parents had very, very unusual taste in names. Call your employee that you work with by their name. Call the customer or client by their name. If you do not know their name, you can call them by their job title. If you're absolutely certain of their gender identity and expression, you can call them ma'am or sir. If you're not certain, you can always say, "May I help you?" or "Good morning," or something of that nature. Your coworker is not named Honey. Women find that very, very offensive. I suspect that most men find that offensive too. Usually we find the women complaining about it the most because they tend to be the ones on the receiving end. When we talk about conduct that anybody might object to, the legal standard that we use is sometimes called the reasonable woman standard. The reasonable woman standard was developed back in the days when we used to think that women were the only ones who could be victims of sexual harassment. What the reasonable woman standard says is that when the victim of discriminatory harassment is female, you look at the conduct through the eyes of a reasonable woman in the victim's shoes. If it's conduct that a male or female employee might treat differently, the woman's perspective is the one that counts. And this goes for all other classes of discrimination as well. In religious discrimination, a reasonable member of the victim's faith, a reasonable Jew, a reasonable Sikh, a reasonable Buddhist, a reasonable Catholic, a reasonable fill in the blank with whatever that religion is. If it's race or ethnic origin, a reasonable African American, a reasonable Chinese American, a reasonable Mexican American, a reasonable German American, a reasonable whatever that group happens to be. That's the standard we use. We want to make sure that we are looking at things through the eyes of a reasonable person in the victim's shoes. Now, we got a few participant questions. I want to address some of these right now. One of them asks, how do I respond to an employee who claims to be a victim of unlawful harassment when I don't think they actually are? It appears that what's actually going on is a simple personality conflict. A separate person asks the question, how do I respond to an employee who's overreacting? Again, they don't think that it's really discrimination going on here. One thing I would remind you at this point is that the legal test is reasonable woman standard or reasonable person in the victim's shoes standard. Be aware that even if you don't find that statement offensive, maybe a reasonable person in the victim's shoes would. The question is not, do you find it offensive? The question is, does that victim find it offensive? What if they really are overreacting? At that point, something else kicks into play, and that is just plain old respect and treating people decently. Frequently in cases like this, the appearance of fairness and justice is every bit as important as the reality of fairness and justice. Maybe it really was just a simple personality conflict. Maybe that person really was overreacting, but you still need to take them seriously and treat them like they're giving a legitimate complaint, because treating the employee with respect can help to minimize the harm that they've suffered. You've got somebody who's already feeling like they're being mistreated. Don't pile on by blowing off their complaints. Treat them with respect. And then if you decide that they're overreacting or it's a simple personality conflict, then deal with it as a supervisor as a personality conflict, but deal with it. More danger spots. Nonverbal harassment, gestures, stalking, staring at people, practical jokes. Tell your employees to keep their eyes to themselves. Don't be giving people the elevator eyes up and down. It is not appropriate. I do a lot of sexual harassment prevention training. I get a lot of employees who say things like, well, yeah, but the person is dressed in a provocative manner. You can't control that the person is dressed in a provocative manner. You can control what you do with your own eyes. Inappropriate visual displays. Do be aware that everything you bring into the workplace is something that you have brought into the workplace and needs to be appropriate. Watch out for things like cell phones. The lock screen on your cell phone, the cell phone cover needs to be something that's appropriate for the workplace. The clothing that you wear, make sure that messages on your clothing are appropriate for the workplace. Visible tattoos should be covered if they have anything that's even halfway dangerous. Magazines, goes without saying, porn needs to stay out of the workplace. Leave the Victoria's Secret catalog at home. Leave the Sports Illustrated swimsuit issue at home. Pictures that you post in your workspace, like your cubicle, be aware that you're posting a picture of a human being. If you've got the child who is the competitive athlete, you're probably okay with a tennis player. If the child is a competitive swimmer, diver, wrestler, gymnast, be aware that they might be wearing a little bit less clothing than is appropriate to be on display at the workplace, and have the picture cropped or show them in their warm-up gear. Watch out for screensavers. I'm going to start moving even faster now. We're going to look in more detail at a few legally protected classes that are worthy of additional mention. Race, color, and national origin. For national origin, be aware that language discrimination is national origin discrimination. A lot of workplaces have rules requiring employees to speak English only in the workplace. These rules are presumptively illegal. They are justifiable if and only if the employer has a very, very good reason for requiring them. Things like if the employee has to communicate with customers who only speak English, in emergencies or other situations where you have to speak a common language, for cooperative work assignments, things like that are okay. But having a rule that requires employees to speak English only while they are off duty in the break room, absolutely illegal. Religion, be aware that religion includes not just membership in a formal religion, but also any kind of religious practice, and it also includes non-religion. So if the person says, I'm an atheist, that counts as religion too. Be aware that the religious employee has a legal right to minimal accommodation. If you live any place other than California, the rule is de minimis, very, very little. De minimis is a Latin phrase that means very tiny bit. In California, the requirement is legally is more than de minimis under California's Fair Employment and Housing Act. So California employers need to be a little bit more accommodating than employers in the rest of the country. Be aware that imposing religious beliefs on others, the employee who tries to share their religion a little bit too generously in the workplace, runs a risk of violating their coworkers' religious rights. So you want to make sure that employees aren't preaching too much in the workplace. Disability. Be aware of paternalism. If you've got an employee who has a disability, don't try to make decisions for them that they can make on their own. Please remember that your coworker is a grown-up and they are a professional, and they've lived with their disability for a lot longer than you have, because they've had it for, they live with it 24 hours a day. They know what kind of accommodations they need better than you do. Don't stereotype individuals with disabilities. We frequently encounter all sorts of weird stories about an employee who's a wheelchair user and somebody tries to give them things in Braille, or an employee who's deaf and people try to make them use a wheelchair. Again, respect your coworkers' knowledge of the best accommodation for their own disability. Be aware that you do have to reasonably accommodate an employee with a disability. That could be a whole hour in itself, and in the interest of time, we are going to move on. Sexual orientation and gender identity. Employees in most states are protected against discrimination on the basis of sexual orientation and gender identity. A few things to be cautious of here. One is double standards. If you are having a work-related activity and he is permitted to bring his female girlfriend, then the other he must also be permitted to bring his male boyfriend to the same activity. If a woman can have a picture of her male boyfriend on the desk, a male employee has to be able to have a picture of his male employee on the desk. With respect to pronouns and forms of address, call the employee by whatever pronoun they prefer. If they want to be called he, call them he. If they want to be called she, call them she. If they want to be called they because they're Non-binary, call them they. Call people by the names they prefer to be addressed by. Restrooms, everybody has to use the restroom. Everybody has the right to use it safely. Allow employees to use the restroom of the gender that they identify with, particularly if you are in California. This is a California state statute. There are a few issues that are unique to sexual harassment. I'm going to go over just a few of them very quickly. One is, I'm going to call it attraction and animus. I will get to that and explain it more fully in just a minute. Tangible employment action harassment, which happens only in sexual harassment. And then we'll talk a little bit about the content of the harassment and same-sex harassment. Attraction versus animus, something that is very, very unusual in the case of sexual harassment is the concept that a person might be experiencing discrimination not because the harasser doesn't like them, but because the harasser does like them. Usually harassers bother people because they don't like people in that category. In sexual harassment, you get the exact opposite, where you get somebody who's maybe too attracted to somebody and is expressing that attraction in ways that are not appropriate. One of my favorite examples of this scenario is a California case called Chapurian. A woman named Annie Chapurian was a female physician assistant at a Sacramento area hospital where she was having a lot of trouble with two doctors. Time does not permit us to go into the detail. We will suffice it to say that there was one doctor, we'll call him Doctor Number One, who was hitting on her constantly, saying things like, I'm horny, grabbing, groping, engaging in verbal sexual fantasies about her and other women. There was a second doctor, call him Doctor Number Two, who was frequently insulting to her in the operating room and would routinely say things like, stupid chick, you operate like a girl. The actual facts were far worse than what I've given you in only 1 minute, because I only had 1 minute. But the bottom line in this case is that Ms. Chapurian complained about the conduct of both doctors. The hospital did nothing. She wound up getting a reputation for being a troublemaker, was ultimately fired, and then she brought a lawsuit. And the jury got to hear in glorious detail for 2 months just exactly how badly these two doctors had been behaving. The jury then went into the jury room and engaged in some deliberations. They learned two things about themselves. One thing they learned was that they were very, very angry. The other thing they learned was that they were not very good at math, and they were having a lot of trouble adding up the large dollar values that they were thinking of awarding to Ms. Chapurian. So they sent the judge a note that has become famous in the annals of sexual harassment litigation as being the note that you never, ever want to have the jury send to a judge if you represent the defendant. May we please have a calculator? We don't know how to count that high. The judge gave him a calculator, and they added up a bunch of numbers, and the bottom line was, in round numbers, $168 million. At the time, this was the largest single plaintiff sexual harassment verdict in the history of the country. For our purposes, the Chapurian case stands for the proposition that sexual harassment can happen either based on attraction or animus. Jury verdicts also can be very large. They're not usually this large. Moving forward, tangible employment action. Tangible employment action harassment occurs when a supervisor ties some kind of tangible employment action, like firing or getting a promotion or getting a raise, to the victim's willingness to submit to the harasser's sexual demands. I'll fire you if you don't sleep with me. I'll give you a promotion if you do sleep with me. Tangible employment action harassment is pretty much unique to sexual harassment. It is considered to be a variety of job status discrimination, actually, as opposed to harassment, but it's also harassment. The definition of hostile environment sexual harassment. This is the federal definition. Unwanted sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature, when such conduct has the purpose of interfering with an individual's work performance or creating an intimidating or offensive work environment. I want to give you one other definition. We're focusing here right now on the phrase conduct of a sexual nature. This is California law, which actually is identical in this respect to federal law, but the statute breaks it out into two categories. One is harassment based on sex, the other is harassment of a sexual nature, and the legal test is satisfied if either of these conditions is met, either harassment that is based on sex or harassment of a sexual nature. Federal law works the same way. Sometimes sexual harassment has sexual content but is not based on the victim's sex. There was a case about 2 years ago out of New York where a male firefighter said to a coworker, I'm going to paraphrase this in the interest of keeping the language clean, I am extremely attracted to your teenage daughter and would like to sleep with her. We have here highly offensive sexual content. It does not matter if you say that to mom or dad. Either way, it's highly offensive. The victim sued, the victim won. Conduct can be based on sex, but lacking sexual content. Several years ago, I worked on a case myself where there was a sexual harasser who went around the break room in his workplace trying to talk dirty to the women in the break room, but he was remarkably ineffective at it. The reason that he was remarkably effective was that he mistakenly believed that the word cheese was a dirty word. And so he would go around asking women in the workplace if they had cheese on their sandwiches or were they eating cheeseburgers or things like that. There was no sexual content at all, but the women complained because he was very, very annoying, and he wound up getting fired for sexual harassment, even though there was not a victim in the place who even knew that he had been trying to talk dirty. Very strange case. Be aware that same-sex harassment is actionable. Under federal law, there's a 1998 case called Oncale. Jody Oncale was a victim of serious sexual harassment. Few things to note about the Oncale case. One is that both the victim and the harassers were heterosexual. This was severe sexual harassment that went under the name of horseplay, but it was a lot more than that. It was a heterosexual victim, heterosexual harassers. None of the harassment was motivated by sexual desire. The Supreme Court says it does not matter. It does not matter that the victim and harassers are heterosexual. You don't need to have sexual desire. If there is sexual content, which there was, that's enough. Be aware that nationwide, about 1 in 6 sexual harassment claims are filed by men. That number has been consistent over the last 5 years. We're getting very close to the end. Where are we now? We've talked about a few protective classes. We've said that conduct is severe or pervasive. We've talked about a reasonable victim standard. We've talked about some of the forms that harassment can take. We talked about a few issues that are unique to sexual harassment. And we said be nice to everyone. A couple of quick participant questions. One person wrote in saying, how do I ensure that the employees that I supervise will comply with the anti-discrimination laws when I work in a field where discrimination is rampant? This person mentioned the specific field that they work in. I intentionally removed it from the written version of the question that I gave you because you can, in fact, say this about almost any field. Nobody is immune. How do I get the employees that I supervise to comply with these laws? Well, we're moving on then to setting the tone. The best thing you can do, first of all, is to not do it yourself. Make employees know that you support the policy, live it, talk the talk, walk the walk. Zero tolerance has to be the rule. Take complaints seriously, act quickly, discipline appropriately. Model the behavior that you expect to get from the people that you supervise. Bullying and abusive conduct in the workplace is a very serious issue. The California State Legislature, in fact, is concerned about it enough that they've got a definition conduct with malice that a reasonable person would find hostile, offensive, and unrelated to an employer's legitimate business interests. How do we respond to this? Well, one thing to do if you're a supervisor, obviously you don't do it yourself, don't tolerate it in others, and keep an eye out for specific kinds of job sabotage conduct. It turns out empirically that job sabotage is the most common form of workplace bullying. You're not looking for somebody who is stealing people's lunch money. That might be the sixth grader. What you're looking for, keeping an eye out for, is an employee who refuses to work with other employees, who refuses to help them, who tries to sabotage somebody else's work, who refuses to give them the resources they need, somebody who steals credit for other people's work, somebody who falsely accuses coworkers of errors that they haven't made. That's the kind of thing that you want to be looking out for. Respond to it appropriately, respond to it quickly. Make sure that you define behavior when you're onboarding new employees. Don't postpone conflict resolution. Now, choose your battles. Sometimes you're going to have to just let people work it out on their own, but listen to your employees, remain impartial, think about it before you act, promote problem solving, encourage them to solve their own problems, and do discipline if necessary. You may have to. You're going to onboard people, you're going to set them up for success, you're going to have procedures in place, you're going to investigate, you're going to be consistent between different employees, you're going to consider all of the relevant factors that you can think of. Document the heck out of everything. I love the word document. It's one of my favorite words. Retain confidentiality to the extent that you can, and make sure that you model professional behavior of your own. Be competent, be available, be respectful, listen to your coworkers, get along, play well with others. Before I move on to the questions in the very little time that we have available, I do want to tell you just one story about something that happened to me when I was in law school. I had the privilege of attending a law school where we had made a conscious decision that we were going to be a place where people treated each other well. I had a classmate named Jeff who was totally blind. And the fact that Jeff was totally blind was creating a problem with regard to his reading. Law schools, as you might imagine, there's a lot of reading when you're a student. The material was difficult, and the reading for the blind facility locally was being taxed to its very limits. They couldn't find enough volunteers who were capable of reading that much material of that difficulty level so that Jeff could do his homework. We became aware of this situation. So one day, a classmate of mine made arrangements, and a big group of us, it was about 25 or 30, took over the entire reading for the blind facility all day. Every studio, and we read in this one marathon session almost an entire semester's worth of books onto tape. Later on, I was telling this story to a colleague of mine who attended a law school where the attitude was very, very different. When I told her this story, her eyes bugged open and her mouth popped open, and she said in this tone of disbelief, "Law students would do that for each other?" Well, yeah, they would. I took it for granted that people would do the right thing and treat each other well because we had made the conscious decision that we would be an environment where people would do the right thing and treat each other well. My colleague was from a different environment. If I could leave you with one thing, you can have an environment in your workplace where people will treat each other well and they will do the right thing, but it takes a conscious decision. And I see that I am entirely out of time. I had some other participant questions that I would love to get to, but we are out of time, so we will have to get back to you individually, and I will turn the time back to Julie.
Okay, well, Thank you very much. You're right. We are at time now. I want to thank you, Alice, for a great presentation, and thank you to everyone who joined us today. Again, we will send an email with a link to the recording and the slide deck, and if you sent over a question that we were not able to address in the body of the presentation, we will be sure to get back to you with an answer to your question. Thank you and have a great day.